Hello guys, welcome to this video. In today's video we are going to look at a case law on error of law. So the case that we're looking at is the case of Brutus versus Cozens in 1973. So without further ado, let's dive in. So the appellant was charged with using insulting behavior during the annual tournament at the All England Lawn Tennis Club, Wimbledon, on 28 June 1971, in protest against the apartheid policy of the government of South Africa, contrary to Section 5 of the Public Order Act of 1936 as amended. The magistrates concluded that the appellant's behavior was not insulting as required by the offense. The divisional court was asked to state a case to determine the meaning of insulting behavior under the act. The appellant appealed to the High Court. So the act that we are talking about is the Public Order Act of 1936. So was there an error of law in the interpretation of this act? Let's find out. So here are the issues. 1. Whether the behavior of the appellant constituted insulting behavior as defined by under Section 5 of the Public Order Act of 1936. Secondly, the issue is that whether the magistrate's decision was a matter of fact or law. That whether disrespect for the rights of others automatically constitute insulting behavior. 4. We have whether the reaction of witnesses to behavior is relevant to determining if it was threatening, abusive, or insulting. So this is what was held in court. The High Court held that the behavior of the appellant did not meet the threshold of insulting behavior as required by the Act. The court emphasized that disrespect for the rights of others does not automatically equate to insulting behavior. The court also ruled that the reaction of witnesses to the behavior does not determine if the behavior was threatening, abusive, or insulting. The High Court allowed the appeal with costs. So what was the rationale and the reasoning of the court? The court noted that the Act does not provide a specific definition to insulting, and previous cases did not suggest a unique interpretation. The court stated that insulting behavior must be proven to justify conviction, not merely behavior that is annoying. The court determined that the magistrate's decision was based on a question of fact, not law, and they did make a specific finding of insulting behavior. The court concluded that the behavior in question did not meet the legal standard of insulting behavior as required by the Act. So we find that in this case that the High Court allowed the appeal with costs and overturned the decision of the magistrates, ruling that the behavior of the appellant did not constitute insulting behavior as defined by the Public Order Act of 1936. This case is a very clear example of a case involving error of law, whereby magistrates committed an error of law that the High Court overturned. Thank you for watching this video. Like, share, and subscribe.